Hello, my name is Ryan Craig. I'm the owner of QC's Building Services and a licensed building and timber pest inspection consultant. This video is designed to give clients really important information about one of the components for the inspections done at the time of a purchase of a residential property, and that is about the building inspection side. It is a long video, but can I just encourage you to stay the course and listen to all of the information within the video, because it's of such critical importance for purchasers to know about. A lack of understanding on these issues that I'm going to raise does result in severe financial stress, financial loss, major emotional stress, and purchasers buying something that they weren't aware of because they weren't fully comprehending what a building inspection does, its limitations, and what they could have done to overcome this. So basically the current environment for purchasers when they buy properties, residential properties in Queensland, is extremely inadequate, inept, and it runs high chances of them, which I see frequently during the course of my inspections carried out, getting into situations legally. They've got no protection, they're buying properties uninformed and not what they think they are, and there's no legal availability to withdraw from contracts because of the way the contract is designed. What I mean by that is the REIQ, which is a governing body for real estate agents, actually have a hand in designing the contract that is predominantly used for the purchase and sale of a property, and it's littered in terms of the building and pest inspection clauses with stuff that is so favourable for the vendor and which can be overcome by a purchaser. But at this stage, in that current environment, many don't, because they simply get manipulated at the time the contract's filled out. Purchasers don't understand the importance of the clauses in the contract, the ramifications they have. So invariably when I do my job and get to them and advise them of certain things, it's too late because they've signed the contract and it's legally bound. So just understand the importance as a purchaser that all of the information that you deal with in terms of building inspections ties in with the contract. So you must manipulate the contract earlier on to make sure your building inspection is the most powerful and positive, and gives you in terms of information you receive, quality of, and also gives you the legal ability to act and withdraw on the contract, which the current one does not, because it's been designed by the real estate industry. So we'll elaborate that in some of the other videos. One of the things I wanted to say was just exactly that: manipulate the contract at the time. You must add clauses in the contract to have provisions for certain things to be done as part of the contract which is binding. So for instance, a standard building inspection, legally, the provisions in the contract will not allow for the inspection of some critical components of a property and structure that cost a lot of money to repair. So you've got no chance of being aware of it as a purchaser if you engage a company that inspection company that only adheres to the minimum requirements. We'll cover that as well in the video in a minute, and why you shouldn't do that. Or you don't manipulate the contract to ensure that you've got clauses in there that allows you to do this. The standard contract just says you can get a building inspection done. It doesn't stipulate what can be in that building report, and most inspection companies sadly will only adhere to the minimum requirements, and I'll cover what's excluded a bit later. So you must amend your report at the time it's signed and add things in like, I want to do a search on the ducted air conditioning system because it can cost a lot of money to fix. Now, a standard building inspection doesn't have the ability to test the components of a air conditioning ducted system, because it can cost so much, you should get an independent audit because of the risk associated for repair. And also swimming pools is another one. We would always recommend that a pool should be completely audited by a professional licensed company so that things like subterranean leaks can be tested and identified. And there's provision in the contract that says that for you to withdraw or act on it if you're advised of that. Not doing that may result in you, if you buy a property with a pool, with thousands of dollars of costs that you won't know about, because the current system puts you in that situation. So these are all things as a purchaser you've got to know of and not assume are being done for you. The minimum guidelines within the Australian standard are dictated. There's one other thing I'll just talk to you about with what you need to put in the contract, and we're going to touch on this a bit later, and that's, you should really put a thing in the contract at the start, part of the building inspection, which is not done by a building inspector, that says in the clause in the contract you can do a search of the property, legal search, and this is to do with the Brisbane City Council or council authority, in order to determine what characteristics of property are formally, legally on their records. So that, what I'm saying there is, if you're buying a property that's been marketed 4-bed, 2-bath on the internet, you can't trust that. You should put it in your contract that you should be able to do a search with the council, and that if that is not correct, you can legally withdraw from the contract. And I'm going to explain and elaborate on that in a couple of seconds. Right, the Australian standard for building inspections is governed by Australian standard 4349.1, and that was last reprinted in 2007. The standard outlines the scope, conditions, and the limitations of an inspection. It is a minimum guideline only. Regrettably, the majority of inspection companies who do pre-purchase inspection work will only adhere to this standard. You can exceed it, and good companies will exceed it. If you don't exceed it and you adhere to the minimum requirements, you're going to get not the information you need as a purchaser to act on and be properly informed, and you're going to increase your legal risks of not being able to withdraw from a contract because it's not in the building report. Never ever engage an inspection company that say they're only going to adhere to the minimum requirements, and as we go through this video you'll understand why. You always should engage an inspection company that will exceed the requirements in the standard and give all pieces of information they think they can benefit you with, irrelevant of whether or not it's required in the standard, etc. So the purpose of a building inspection within the Australian standard is basically to provide advice to a potential purchaser on a property about the condition of the property at the time the inspection was done. That's basically the purpose of the inspection. The scope of the inspection is that the inspection shall comprise a visual only assessment of the property, primarily to identify any major defects. I'll give you the definition of a major defect in a minute, and to give a general condition overall of the property, a general assessment. There's no requirement whatsoever for an inspection company to individually itemise minor defects, but good companies will, and that's how we operate. The standard also excludes for a consultant or inspection company to comment in any areas they are not considered to be an expert in or licensed. Now, that can be plumbing, it can be electrical. Now, if you don't get an inspection company that is prepared to comment in those areas, you're going to run the risks of, because they should have very good experiences in those areas, being a builder, licensed building inspector, you're going to run the risk of not getting good quality information in areas like plumbing and electrical that you could have got if a company was prepared to talk about it. Now, we operate like that. We exceed the standards and comment on absolutely everything. There will be a need to put a disclaimer in for any areas that you're not licensed or are not considered to be an expert in, but our attitude is that it's much better for us to comment about it because we have good information, pass that on to our client, disclaim it legally because we have to, and then they can act on that information and be in a far better position to minimise the risks of any financial loss. So the most critical thing for a purchaser to be aware of about a building inspection is actually something that's not included in a building inspection, funnily enough, and that is if they don't know about this issue, then they're going to be at serious risk of buying something that is completely not reflective of what was marketed to them, and they will run a really big risk of sustaining financial loss. The fact it's so prevalent in the real estate industry and purchase of properties is disgraceful, and it shouldn't be allowable, but it is, and that is the following: that there is no legal requirement imposed on a purchaser at the time they make a purchase of a property, to validate the product and to authenticate that what has been marketed on the internet, on domain, on realestate.com is actually what it is. What I mean by that is most purchasers will simply look at domain and realestate.com and see a property marketed by the agents and it says 4-bed, 2-bath. They just lock it in that that's what it is, 4-bed, 2-bath. The actual reality is that when we do inspections for people, our clients, and tell them to do a search with the council, which is the only organisation that can determine what the characteristics of a property are, 50% of the times, 50% of the times, not 15, our clients find out that what was on the internet is not a reflection of what the reality is on the official records with the council. So what I mean by that is, as we said before, it's 4-bed, 2-bath on the internet. The people do a search, the clients do a search with the council, and they're told, oh, look, I'm sorry, but our records show that that property is actually not any building work registered for the site, unapproved building work, illegal building work, or it had a building approval, but it was not completed and hasn't had the final inspection certificate, so therefore it's incompleted building work. All of those are problematic. It's certainly not the truth and a reflection of the 4-bed, 2-bath that's been marketed to you. The only organisation that can tell you what the formal records are of a property is the Brisbane City Council or the local council authority where the property is. Never ever rely on the advice of a marketing agent because it won't be truthful on many occasions, and they don't have any desire or need to verify what they market as being factual by doing the search I'm talking about. And again, the most disappointing thing about this is this issue is excluded from a standard building inspection. Again, in my opinion, it should be the first thing done. It's the most important thing for a purchaser to know. I would never buy a property ever if in the future, knowing what I know now, unless I've done a search with the relevant council authority and I know that the characteristics of the property are those, and if it matches what it does on the internet, never would I act on the information on the internet. So there's no provision in the building inspection standard to do this search. Most conveyancing solicitors won't do it for purchasers because they just don't do it, which I don't understand. The purchaser has to be in control and empowered about this issue, and they must change the contract before it's filled out and put a clause in allowing them to do a search and pull out of the contract if it's found to be, the marketing's found to be not truthful or incorrect. Currently, there's no provision for that. Purchasers can buy a property based on the internet and they're held to the contract and have no provision to get out of the contract under the legal conditions of the contract in place, which is disgraceful. So that's why it's the most important thing to know about. Okay, the reality and effect of what a purchaser doesn't, the reality and effect of engaging a company that doesn't exceed the Australian standards. So I'm moving on from that issue now. We're talking about building inspections now. So we're going to the conditions of a building inspection and what will happen if a purchaser engages a company that only adheres to the minimum standards. Clearly, they're not going to get information in areas where they should have got information on and could benefit from, and therefore they don't have the knowledge to make the best possible decision, and they run the risks of buying a property with defects that could have been told to them or issues that they could have been told about and suffering loss. The other thing is legally, if it's not in a building inspection report, any information, there's no ability for a purchaser to withdraw from a contract. The provision of the current contract in use for the purchase and sale of a property states that a purchaser can get a building inspection report, withdraw from the contract if they're not satisfied with the findings of that report, and they must act reasonably. If it's not in the building report, forget about acting on it and withdrawing. So any things that come out that a company who only adhere to the minimum standards haven't talked about, pools, certification matters that you might find about, you won't be able to withdraw from that as part of your negotiation and due diligence because legally you don't have a standing. Companies who exceed the standard and comment in areas over and above the minimum requirements, which we do, put everything in the report and you can act legally if that's the case, but most don't. So you've got to ensure you know who you're engaging. The definitions of the major and minor defects as per the Australian standard. A major defect is anything that has a significant magnitude where a rectification has to be required in order to avoid unsafe conditions. Or the second component of a major defect is anything that causes a loss of utility. And the third, and one that we have the biggest problem with, is anything that has a safety risk or is a safety hazard, must be categorised as a major defect. So that's the one, basically where do you stop with that? A major defect, you could have something like a raised paver, but I'll cover that in a couple of minutes about the costs and stuff. So we'll do it now actually. So anything about a major defect, the term major defect to me and us sounds very significant, and a lot of our clients often get lost in the need for us to comment something as a safety hazard because it's contained in the Australian standards, a definition for a major defect, like a raised paver. Now the cost to fix a raised paver is minimalistic, nothing, but it has to be called a major defect in the building report because it's a safety hazard. Someone could trip over it. Completely and utterly can be misread by purchasers who aren't aware of this and the reasons for the definition of major and minor defect. So for that reason, when you get a building inspection report, understand the terms of the major and minor defect, and particularly that there's no relevance to any cost association for a defect in terms of if it's major or minor. We believe there should be. We believe that if a major defect was more categorised as something that had a cost of a minimum of $5,000, then it would fit the definition of being a major defect. The current definition within the standard has no relevance to cost, and what happens is then often you can get defects that are a minor defect or a major defect, where a minor defect costs more to fix than a major defect under the terms of the standard, which is nonsensical in our opinion, but that's just the reality. So if you understand that as a purchaser, you won't get confused when you read a report and read major defect and think, wow, it's going to cost a lot of money, because that's not the case. A minor defect is basically, the definition under the Australian standard is anything that is not a major defect. Again, completely ambiguous and widespread and lacking clarity and specifics. So the key message here is that anything in the building report that a purchaser reads that is classified in a major or minor area should not be automatically assumed it's cost related and associated costs to that. You should check with the consultant and the inspection company who's done the inspection for you and get a clear understanding of anything in the report irrelevant of major or minor defect association and categorization to cost and potential cost. Don't do it by reading the report because the definitions in the standard can be misleading. Okay? The other thing that you should appreciate as a purchaser and be aware of for building inspections is the inspections are visual, non-invasive. They involve no physical removal of materials or any other sort of fixture to increase the visual capability of the consultant. So there are limitations because of this, like we can't see into under floor coverings, in wall cavities, floor cavities, and behind furniture items and stuff like that, because that's what the standard stipulates the inspection as: visual, non-invasive, nothing's moved. Because of those limitations, there's areas we can't see, but it is the best thing an inspector can do, a purchaser can do, as part of their due diligence in relation to the potential property purchase, i.e. organise a building inspection, so long as they don't organise one that is minimalistic and a company that only adheres to the Australian standards. You will only get benefit from it if you organise a company that exceeds the Australian standards and goes to the effort required to give you all the best information possible. Even if you get a good company like that, they are going to be hamstrung by what I'm talking about now, which is that inspections are visual and non-invasive. Some of the effects of this on an inspection can be that a consultant can't concisely and accurately determine actual causes of a defect that is found because it's in a concealed area. They can't determine the full extent and the costs required for rectification of that defect because it's in a concealed area, like a leaking shower that is identified, but a lot of the defects are behind the wall cavity, so you can't see the core issues because they're concealed by lining, so they have to be removed to determine that. What can you do to overcome this? So to overcome this, inspection companies will make recommendations for, if they find a defect where further investigation should be required, they will say, look, I've found this issue. We recommend that further and more invasive inspections be done, which is basically the removal of any material in order to give better visual accessibility, and we can determine then what the causes are and the full extent of the problem. Only by doing that can you find out the true extent, and it is very important that you recognise as a purchaser the term invasive inspection, the fact that an inspection done is visual only, and why an invasive inspection can be so critical and beneficial when it's recommended in certain areas. They are difficult to try and get done. It requires the approval of the vendor, most of which are hesitant for any material to be removed, like a plasterboard wall. They don't want their property to be damaged. And there's a complete disrespect or lack of understanding shown towards the purchaser by a vendor, because the reality is, unless invasive inspections are done in certain areas, there's ambiguity and it's unclear as to the extent of the problem. So, but unfortunately, if a vendor doesn't say it can be done, you are stuck because it's their property. Invasive inspections can only be beneficial, I believe, in localised areas for specific things, and a leaking shower is one of them. They're not overly successful for defects that can be in different areas of the structure, and a great example of that is termite damage. If you find some termite damage in one part of the property, by doing an invasive inspection where the damage is, that doesn't mean that you've identified the true extent of all damage at a property, because they could be damage in other ends of the structure, who knows. But with a leaking shower, an invasive inspection can be very beneficial because it's a localised area and there's no risk of their defect being anywhere else in the property. So understand when and where an invasive inspection could be of benefit and where it may not be of complete benefit. Now, the areas to be inspected for a building inspection are detailed in the Australian Standard: the site within 30 metres of the main building, the exterior of the structure, the subfloor if applicable, the interior, ceiling void space if applicable, and the roof exterior. Now, the Australian Standard also determines, and some other legal considerations like workplace health and safety, have restrictions on what a consultant can do, because legally they're not able to do certain things. A good example of this is for roof cladding. Within the Workplace Health and Safety Act, it says that any area on roof cladding must not be physically accessed, and can only be accessed visually from a 3.6 metre ladder on the ground. So basically, there's no physical access allowed onto roof cladding for most residential properties, if not all. They can only be inspected visually. So that's not because the consultant doesn't want to go on the roof, it's because the law says he's breaking the law if he does, and he's not allowed to. The only way you can access roof cladding is to have fall protection. This is just one example of a limitation. There are others, and it's strongly recommended that all purchasers familiarise themselves with these limitations And these limitations should be fully explained in a pre-inspection agreement document that an inspection company gives to a client before an inspection is carried out. In that particular instance of the roof cladding, it gets harder to overcome that limitation when it becomes 2-3-story structures, because you can't see, and one story, single story with a ladder, you can see from the ground. So, but familiarise yourselves with all of the limitations of the inspection and know what you can do about it as a purchaser. So that way you know exactly the conditions that the inspection was done, and you know what was excluded, and you know how your decision can be made and anything you need to do to get more information. General information about the report. The length of the report, very long nowadays. When we first started, I started first doing this job 20 years ago, there used to be 20 pages for a building report. Nowadays they're minimum 55, average 60, they can go up. Why has there been such an increase in 20 years? The answer to that is litigation. It's a litigious environment in society and our industry. Anytime there is an example of litigation carried out upon a building consultant across Australia, the insurance companies will send out a global release to all inspection companies saying, put this in the report. Therefore, there's a lot of recommendations in the report which seem crazy and very long and cover all the bases. Not the consultant doing this, but legal precedent and the insurance companies demanding it be done. A good example is there's a recommendation for a consultant to say to their client in the report that where mature trees are present on the block close to the structure, that the client should consider, keyword is consider, engaging an arborist to come and check those trees for their integrity. Now that seems like overkill, unnecessary. However, based on litigation in previous years, when an inspector didn't actually do that, they were sued by the client, who alleged that they had a duty of care to put in their report at the time that they should have done that and got an arborist, and had they told them to do that, they wouldn't have been, they wouldn't have had a problem. The tree wouldn't have fallen on because it could cause damage to their structure. The consultant loses, he has to pay money. So the inspection company says, right, for every inspection from now on, every consultant that does a job where there's trees must put a recommendation in for the purchaser to consult an arborist, to consider consulting an arborist about mature trees. So it's all based on recommendations, previous litigation and risks for known legal precedents. So you don't have to act on all of the recommendations in a report. That's the key message I'm trying to say here. They are all important, they're relevant because of what I'm saying. It protects the consultant, so you can't dismiss them, but appreciate them and their intention within the report. Some are more important for you to act on, like known defects with showers that you must act on immediately and do those kind of things. Do you really need to get an arborist for trees that are within the block? Well, if you don't, then if the tree falls on your property, then it'll be at your risk because the consultant's protected himself by putting that in the report. But if you don't understand that and you read the report and think you must get an arborist for everything and you act on every recommendation in the report because of those legal reasons, invariably you probably won't buy a house because there's too many recommendations made based on legal precedent and requirement for the consultant to exercise his duty of care. And it's unfortunate, but that's the reality of how these reports are done. So if you understand that as a purchaser, you're going to go a long way in not getting extra anxiety or stress or potentially not buying a property for the wrong reasons. So understand the nature of the report and how much of it is a necessity for legal reasons, and not that you absolutely need to act on it, but it needs to be in the report to protect the inspector, so it's not completely irrelevant. The three things you need to do legally when you buy a property under Queensland statute law, a residential property for a purchaser, is you need to do your smoke alarms, pool fencing, and safety switches. That's all incumbent and required legally as part of the process. Some of them can involve the vendor, like the pool fencing, but as a purchaser, ultimately it will fall on you unless the vendor does some of these things. Legally, you have to do those things. Everything else that's in the report is not a legal requirement for you to do, but clearly it can be important and it's in the report for a reason. But just understand that part, that it might be in the report to legally protect the consultant and it might not be that important for you to actually do. Okay, so just don't get confused with that. I know I've said that a couple of times, but it is important. The reports are long because of the common law obligations duty of care. And I'll give you another example of how if you misread a report and some of the information in a report, as a purchaser, you can get worried, anxious, and potentially not buy the property. Again, not because it's a big drama, an issue, but it's been misunderstood by the purchaser. So the statute law requirements are the ones I mentioned before: a power, a safety switch, swimming pool, and smoke alarms. But an inspector and a consultant doesn't just have statute law hanging over his head, he has duty of care common law. And this is where the insurance companies often find they're being litigated on, or inspection companies, under their common law duty of care. So over time, the reports have begun to include recommendations based on common law for the consultant to exercise their duty of care and minimise the risk of litigation, but not because a purchaser needs to do it. A classic one is balustrades. So for older properties, it's completely understandable that for a 1930s property, they might have balustrades on their deck that are less than 1 metre, which is the requirement as of today's standards that came in 1998. Understandable because it was built before the standards in 1998, and it was completely normal at the time for a 1950s property or probably before that period to have balustrades less than 1 metre. Now, under statute law, there's no obligation for the purchaser to upgrade that balustrade legally to make it compliant with today's standards for the older property. There's a lot of other things where this kicks into, like handrails for stairs, safety glass. The list is lengthy, but this is just an example with the balustrades to explain why the report and the meaning of it in the report. What the inspector will do in his report will point out that the balustrades don't comply with today's standards. Now, they should go further and explain that that's not unusual because they were built before the standards were there, and there's no need to upgrade them to the current standards. However, legally, they have to put a recommendation in their report for you to consider doing that, because the reality is, if there was an accident, if you buy the property and there's an accident later on involving the deck with undersized balustrades, what the courts will then do, again based on their decisions legally and legal precedent, is say that under a property owner's common law, yes, there was no obligation at the time the property was built to upgrade those balustrades under any statute law, but had the property owner done that, as per the advice of the building inspector to consider it, and had they done that, they would have minimised the risk of the accident occurring, potentially eliminate it from occurring. So therefore, any legal claim made by someone in the event of an accident happening in these scenarios, a property owner would lose based on legal court decisions, that litigation. That's why the inspection company has that recommendation in the report. Now, if you read that literally and you don't read all of it and think, the inspector's telling me I should upgrade those balustrades to 1 metre, not what is that's being said. Understand the difference there and understand your risk, and understand that the reasons for that recommendation by the consultant, do I need to do it? What are the risks if I don't do it? And then you can make a decision about whether or not you decide to do it. So for an older 1920s property, every recommendation made, most of the recommendations made in the report can be relevant to what I'm saying now, i.e. not necessary, but made to protect the consultant and made for legal reasons to minimise their duty of care common law obligation risk. But only a problem for a purchaser if they buy a property and don't do what the recommendations say, like upgrade to compliant materials, if there's an accident and they're litigated. So it's a 1 in a million, but it's all relevant, and that's why it's in the report. If you understand that as a purchaser, you're going to go a long way to not unnecessarily worrying, having anxiety about most of the recommendations in a building report. So I hope that all makes sense, but it is a very important part of how building inspections are actually carried out, and the reports are written more so. Okay, so we're going to move on now to further recommendations made in the report for further action to be taken by a consultant. Once again, these recommendations will be prevalent right throughout the report, and you might read recommendations about a tiling issue and a plastering issue, and then the consultant or inspector will say, we've identified an issue about the plastering. You must consider getting further advice from a licensed plasterer who is a professional in that field about this issue. Now, that's in there again to legally protect the consultant from future litigation. So if you think that you need to act and get further advice from every single thing that's in there saying get further advice, again, you'll probably cause yourself unnecessary anxiety and stress. There will be occasions, however, where a consultant will make that recommendation for further advice from a certain person, and it is required and it is necessary. And you've got to weigh that up and work out what's in the report that's there to protect the consultant, and what's in the report that I really need to act on now because there's a known issue, a defect that I need to get further advice about. Recommendations will be made in the report all about minimising legal risk for the consultant that are still relevant that you could consider doing, but you don't need to do. But if you don't do them, then if that eventuates down the track, then the consultant is protected by putting that recommendation in, and you have run the risks of sustaining financial loss by not acting what was in the report. But again, I'll say that anything, if you get a building inspection report and think, I've got to act on everything in this report, you're just going to go nuts and you'll never buy a place, because there's too many things in there, again, designed to protect the consultant and the company from potential litigation based on past legal precedents. So don't get confused and allow yourself to be manipulated by that fact, okay? Prioritize what's important, understand what's important, and act on that. Everything in the report is important, but it's not as important as the things that you need to act on that need to be done at the time, and what you need to know about that protects the inspection company. Okay, so one of the things you also need to understand as a purchaser is what is excluded from a building inspection. It's really basic and vague, a building inspection, and if done only in the minimum nature of the Australian standard, is not good enough, poor, inept, and will seriously increase a purchaser of sustaining financial loss and increase their risks of buying a property that is not what they thought it was and be problematic for them. Some of the exclusions that are part of a building inspection are as follows. They're not all of them, but they're as follows. The presence of any dangerous material like asbestos, not required for a building inspection to identify. Any information about insulation material, all information about electrical fittings, including whether or not they work or not, driveway gates, automatic roller doors, air conditioning units, extractor fans, you name it, all excluded. No inspection company has to comment on that whatsoever, which is quite scary, because it doesn't take much to grab a remote control from an air conditioning and just test it if you're an inspector. But most don't do that. We certainly do, but just make sure you're getting a company that you engage that does go the extra mile and does these things. They will have to disclaim it, but at least they do it. Rainwater tanks, swimming pools, building certification matters, concealed plumbing, health and safety matters, the list goes on and on and on and on. So all of those things you're not getting in a building inspection, especially if you engage a company that does the minimum guidelines. Know that, understand that, and control who you get to make sure you get the best information. Always engage a company that does give you that best information, because one, you are going to get the information you need to make the decision and be more informed. Secondly, you're going to be better off legally, because it gives you an ability to withdraw from the contract, because the information is contained in the building report, which triggers the actual contract that you've signed for the purchase of the property, and the clauses for the building and pest gives you legal rights to pull out. Anything that's not in the building report can't be used to pull out of a contract, despite its importance. Okay. Two good recommendations we would recommend you do in conjunction with the building inspection being done. One is the search that we recommended before must be, that's the first one, sorry. So there's three really. So do that search that we recommended before about council search characteristics of the property. Secondly, which can often get missed with the purchase of a property and the building inspection. Make sure you organise for your conveyancing solicitor to transfer all warranties that might be applicable to the current vendor into your name, for any building work that may have been done recently, or any electrical appliance fitting that's been put in place that comes with a warranty. Often that's missed, and you'll kick yourself if you buy a property that might have had a new air conditioner put in or new solar power panels, and they're brand new, and 2 years later with a 5-year warranty they break down, and you think, okay, at the time I was told there's a warranty by the vendor, which was true, but it was in their name and you didn't know that. So you go to claim on that warranty and the manufacturing company says, oh, sorry, this warranty's not for you. It's for the vendor, and it's only applicable if you transfer it immediately at the time of a sale. So don't let that get missed. Make sure you tick the boxes and find out are there any warranties and transfer them. The second thing we would recommend a purchaser do, look, a building inspection done properly is very good and can be all you need for to be advised of any issues at a property. But because of the limitations I've talked about with being visual and non-invasive, because of the fact there's no legal responsibility or onus on the seller of a property to declare any known issue to you, and most don't. Most actually do the opposite and try and conceal any known defect, because we find out about it during our inspections, inquire of the vendor, and then they begin to tell us about this problem, which outlays to us that they knew all about it. But our client hasn't been told about it, so there's no effort by a vendor to disclose things. So to overcome that, and there's no legal obligation for them to do so. So the best thing you can do to overcome that, which we recommend you do, which is not done, is to make a formal demand or request of the vendor in writing for them to declare any known issue, past, present, current, about the property that they're aware of, that costs money or anything of that nature. If you don't do that, they don't have any obligation to tell you. If you do it, you've given yourself the best chance to get some information from them or find out that there might be something there, because they might refuse to answer you. Now, if they refuse to answer a simple request like that, alarm bells would go for me. Hopefully they answer it in writing, and then there's an ability for you to have a record that you did do it. They gave you a response, and if there was anything that popped up in the future which was found out that they knew about this and they didn't tell me, you're better off legally, in better legal standing in the event of any litigation. Hopefully it doesn't happen, but by not doing what I'm suggesting, you've got no grounds or no strength whatsoever or claim to support you in any legal side of things. Things you can ask for them to tell you about specifically: any termite activity damage, legal disputes with neighbours, information about alterations and extensions, any current pre-existing building issues that may have had done, costs, warranties, timber pest work, get all the paperwork for certification and warranties, as I said, details of any roof leaks, disclosure on any legal disputes with any neighbour or adjoining neighbour, just basically anything about the property. So there's some examples of what you can ask them. Right, to summarise, I know it's been a lot of information, but again, as I said at the start, all of it's critical, and the more you know about it as a purchaser, the more you're going to be empowered to control the situation and get away from most people I deal with who have been completely manipulated by the system and the lack of legal provision for them to be safe during the purchase of a property. In fact, it's the opposite. They get trapped, and there's very little legal protection for purchasers. Okay, key issues. Most inspection companies who do this work will only give the minimum information in the Australian standard. Avoid them, stay away from them, because you won't get the information you need and you won't have the legal protection you need to act on any information in a building report. The requirements of the standard are very minimalistic. Never engage a company that does that. Always make that the query of what they do and how they do it, and only deal with someone that exceeds the standard and comments in all areas, basically. Understand the definitions of major and minor defect, and don't believe that if it's a major defect in the report that it's anything to do with cost. It's not a requirement of the standard. The Australian standard definition for major defect has nothing to do with cost. So understand that, and don't misread that a major defect in a report might cost very little. Like the paver I said before, which is raised, which is a safety defect. So under the terms of the standard, that's got to be called a major defect. But to fix that, be a couple of dollars, $10, whatever. You could have a leaking shower, however, that could be a minor defect that could be $5,000, $3,000 to fix. So there's the example of where understand the definitions in the standard and don't misread them or allow to be misread. The most important thing you can really do to get the best building inspection is not just sign the standard contract that the agents will put in front of you. Amend that contract to put in clauses and provisions, and do it in conjunction with feedback from your conveyancing solicitor that protects you completely and gives you all of the needs that you may have to make sure you're not vulnerable and lacking protection legally to pull out of a contract for things that are excluded from a building inspection, like pools, ducted air cons, building certification. If you just sign the standard contract and issues are present in those areas and you don't use a company that exceeds the standard or comments on it, you're a sitting duck, and legally you have to buy that property under the terms of the contract. Very difficult for you. Understand that, manipulate the contract at the time it's signed, control that process, and make sure you're protected. Understand the nature of the written report, the recommendations in the report, and why it's like that. It's not necessarily the consultant being a pain or trying to be problematic and confuse you. It's because of the legal, litigious environment and legal precedent and decisions over time. Therefore, as a purchaser, prioritize, understand each thing. What do you need to act on? What do I not need to act on? A lot of the report, most of the report, will not be relevant to a purchaser and is not really things that they should act on. They are necessary to be in the report because it protects the consultant legally if a 1 in 1,000 thing happens in the future, like an accident. But as long as you know that as a purchaser and don't think you have to act on it, then it becomes more of an irrelevancy. You should focus on the things that are relevant, like things you need to get more information on, building searches, defects that are found that do need invasive inspections and that kind of thing. So understand what to act on and what not. If you're confused, try and be guided by the inspection company. They'll have to give you the report, which is very legalese, full of all the legal statements and that. But if you call them, they should be more than happy to talk to you and explain things and give you more directive as to what they think you should really focus on and prioritize on in the report and act on. But they can't do it legally, because if they do that, they compromise the contents of the report. So try and understand it. If you don't, contact your inspection company and try and get some advice. Also, to understand that you don't need to act on every piece of information telling you to get further advice from someone. There will be occasions where you should act on that. If you're not sure, ask your inspection company, but don't think because there's recommendations for you to get further advice from other contractors right throughout the report that on every single occasion you need to do that. It will be there on some occasions, because you do need to do that, but not as frequent as it's in the report. Most of the times it's in the report, it's to legally protect the consultant, so that if anything is found in the future with invasive inspections being done, the consultant has protected himself because he told you to get further advice at the time from a specialist. Now, if you didn't do that, it's a defense for the consultant and it mitigates any litigation. So that's why it's in the report. So if you understand that, you're going to better understand the report and again make a more informed decision and probably reduce your stress levels and stuff like that. So I think that's basically a lot of, there's other videos in our channel here which got information on this subject, but really, really, really important for you to understand that what a building inspection is, what it does, what it doesn't do. Try and control that process as best as you can. And if you do that, you're going to be in a far better position. So I hope you found it informative and it's of use to you. And if you are buying a property in the future, we'd obviously really love to assist you in some manner. And thank you very much for watching.